My husband filed for divorce at 35. I'm taking everything, the house, the car. My lawyer screamed, "Fight back!" But I calmly signed. He celebrated for a week until he found out that all the property... Good day, dear listeners. It's Diana again. I'm glad you're here with me. Please subscribe to my channel and like this video. And also let me know in the comments which city you're listening from. That way I can see how far my story has traveled. There are moments in life you don't see coming. Not because the signs weren't there, but because you chose to believe in something better. I was 35 years old, living in a pale yellow colonial house on Birchwood Lane in suburban Connecticut, married to a man named Daniel Marsh for 11 years. And I genuinely thought, that we were fine. My name is Claire Marsh, or it was for a while. I kept his name through habit and through hope, the way you keep an old coat long after the lining has gone threadbare. Our house had 4 bedrooms. We had 2 cars, a silver Audi that Daniel drove and a white Honda that I used to get to work at the accounting firm where I had spent the last 9 years climbing, quietly and steadily, toward a position that finally paid me what I was worth. We had a savings account, a joint investment portfolio, a dog named Biscuit, and a marriage that, from the outside, looked perfectly intact. Looking back now, I can see exactly when the threads began to pull loose. It was small things first. Daniel started going to the gym at hours that didn't make sense. 6 in the morning on Sundays, 10 at night on Tuesdays. He bought new clothes without mentioning it. He laughed differently on the phone when he thought I wasn't listening. Not louder, softer, more careful. I noticed. The way you notice a draft in a room without being able to find the open window. I told myself it was stress. He'd been passed over for a promotion in the spring and had taken it harder than he let on. I told myself he was recalibrating. Men do that, I thought. They go quiet and strange, and then they come back. But he didn't come back. By October, he had begun sleeping on his phone, literally face down on the nightstand with the screen against the wood so no notification could be seen. By November, he started taking calls in the garage. By December, he had installed a privacy screen on his laptop and changed the Wi-Fi password, telling me the router had been glitching and he'd set it up fresh. I believed him. Or I told myself I believed him, which is a different thing entirely. I remember the night I first allowed myself to think the word. I was standing at the kitchen sink washing dishes, looking out the window at the driveway where his car was gone again at 9:30 on a Wednesday, and the word rose up through me like cold water through stone. Affair. I set down the plate I was holding very carefully because my hands had started to shake. What do you do with a thought like that? I didn't act on it. Not yet. I folded it up and put it somewhere small and kept going. I went to work. I cooked dinner. I walked Biscuit down Birchwood Lane every evening and waved at the neighbors and smiled the way you smile when your face has forgotten how to do anything else. And then came the morning of January the 14th. It was a Saturday. I was still in my robe holding a mug of coffee at the kitchen table when Daniel came downstairs in his work clothes, which made no sense because it was a weekend, and set a manila envelope on the table in front of me without a word. I looked at the envelope. I looked at him. His jaw was set. His eyes were somewhere just past my shoulder, the way people look when they've rehearsed something so many times they've gone numb to it. "I've filed," he said. "My attorney sent those over yesterday. You should get your own lawyer." I didn't move. "Filed what?" He looked at me then. "For divorce, Claire." The coffee mug was warm in my hands. I focused on that. the warmth, the ceramic, the small solid fact of it. The room felt very still and very loud at the same time. "I want the house," he said, "and the Audi. I've listed everything in the papers. My attorney says given how the accounts are structured, I have strong grounds for the primary claim on most of the joint assets." He paused. "I think it's better if you don't fight this." He thinks it's better if I don't fight this. I set the mug down on the table. I opened the envelope. I looked at the first page and then the second, and I understood. Not just what he was asking for, but what he had already been planning. This had not been filed yesterday. This had been built over months. The dates on the supporting documentation went back to August. He had been preparing this since August, while I was walking Biscuit, while I was washing dishes, while I was telling myself he was only stressed. I folded the papers back into the envelope and said nothing. He stood there for a moment as if he expected me to cry or argue or throw something. When I didn't, he picked up his keys and left. I sat at that kitchen table for a very long time. The silence after he left was the kind that sits on your chest. I didn't move from the table for nearly an hour. Outside, a neighbor's car backed out of a driveway. A dog barked once and went quiet. The ordinary world kept turning on its ordinary axis, and I sat there with a manila envelope and a marriage that had apparently ended sometime in August without my knowledge. The first thing I felt was not rage. I want to be honest about that, because rage would have been cleaner. What I felt first was something closer to humiliation. The particular kind that comes from realizing how long you have been the last to know something about your own life. How many people had seen what I hadn't? His friends? His family? Her, whoever she was? I made myself get up. I showered, dressed, and sat back down at the kitchen table with the papers and a legal pad and a pen. I have always thought better when I write things down. It is the accountant in me, the part of my brain that insists on columns and categories and the comfort of a thing written out plainly. I read every page of those divorce papers slowly, the way I read a balance sheet when something doesn't add up, and things did not add up. The asset list Daniel's attorney had prepared was, I can only describe it as creative. The house on Birchwood Lane was valued at 40% below current market. The joint investment portfolio was listed at its value from 2 years prior, before a period of significant growth. Our savings account appeared to have $31,000 in it. I knew because I had looked at it 3 weeks ago for an unrelated reason that it had contained $58,000. $27,000. Gone. I wrote that number on the legal pad and circled it 3 times. I am a forensic accountant. I have spent 9 years finding discrepancies in other people's financial lives. I have sat across conference tables from men in good suits who smiled easily and lied precisely and thought they had covered every track. I have a particular talent for finding the tracks they thought they'd covered. Daniel had always found my work vaguely tedious. He never asked about my cases. He didn't understand what I did. Not really. He thought I looked at spreadsheets and found rounding errors. He had no idea what I was actually capable of. And that, I realized as I sat at the kitchen table in the pale January light, was his first and most catastrophic mistake. I made 2 phone calls that afternoon. The first was to my sister, Rachel, who lives 40 minutes north in Westport and who has the kind of calm competence that I have relied on since childhood. She answered on the second ring, and I told her what had happened without crying, which surprised me. She drove down within the hour. She sat across from me at that same table, read through the papers herself, and said, "Claire, you need an attorney today." "I know," I said. The second call I made was to an attorney named Patricia Nguyen, whom I had found 2 months earlier, not because I had suspected anything, but because a colleague at the firm had mentioned her in passing after her own divorce, and I had written the name down. I don't know why. Maybe some part of me had known something without knowing it. Patricia Nguyen picked up on the third ring and agreed to see me Monday morning. That Sunday, I did 3 things. I made a list of every financial account I knew of, with dates, amounts, and access records going back 3 years. I photographed every page of the divorce documents on my phone and emailed them to a personal address Daniel didn't know about. And I began to think, carefully, quietly, the way I think about a complex case, about what Daniel had and what he didn't have. He had gotten to an attorney first. He had built a document trail over months. He had, it appeared, moved money. But I had something he didn't know I had. I had 9 years of professional training in exactly this. I had access to our joint financial records that was equal to his. I had, as I would later discover, far more than he had anticipated. Because Daniel had always underestimated me, and that underestimation was going to cost him everything he thought he'd won. The plan didn't come all at once. It came the way most real plans do, quietly, in pieces, each one clicking into place with the small, cold logic of a lock turning over. By Sunday evening, I had the outline of it. I was going to let him think I was going to sign. I was going to let him celebrate. And while he celebrated, I was going to find every dollar he had moved, every account he had hidden, and every document that proved it. I wasn't going to fight the way he expected me to fight. I was going to fight the way I actually knew how. Monday morning arrived gray and cold. The sky over Connecticut the color of old pewter. I drove to Patricia Nguyen's office in a 3-story brick building in downtown Hartford, parked the Honda, and walked in carrying my legal pad, a folder of documents, and what I can only describe as a very specific kind of quiet. Patricia Nguyen was small and precise, with dark eyes that moved quickly and a handshake that meant business. She had a corner office with a window that looked over the street below, and she listened to me without interrupting for 22 minutes, which is longer than most people last when I start talking numbers. When I finished, she looked at the papers I had brought, looked at my notes, and said, "He moved $27,000. "At minimum," I said. She nodded slowly. "Do you have access to the joint accounts?" "Equal access. My name is on everything. And your professional background is forensic accounting." "Yes." She leaned back slightly. "Then you understand what we're looking for." "I understand exactly what we're looking for," I said. "I've been doing this for 9 years. The only difference is the client." What I had not told Daniel, what he had never thought to consider, was that 3 months earlier, before any of this began, our firm had upgraded its software for financial analysis. Part of my access package included tools I could use professionally. I had, quietly and within every legal boundary, run our joint financial history through that analysis in the weeks since I had first found the privacy screen on his laptop, not looking for anything specific, just looking. I had found 3 things. The first, 11 transfers over 14 months, each between $4,000 and $6,000, moving from our joint savings account to an account I didn't recognize. The transfers were timed to coincide with periods when I was traveling for work. 4 trips in 2 years. none longer than 4 days. He had waited until I was out of state. The second, a refinancing inquiry on the house, initiated 8 months ago that had not been completed, but which had been used to generate an appraisal. The appraisal in his divorce documents matched that inquiry exactly, despite being 9 months old and 40% below current market. The third was the one that changed everything. 11 months ago, Daniel had opened a limited liability company in Delaware. It was registered under a name I didn't recognize, Marsh Capital Consulting, LLC, and listed a registered agent, not Daniel's name, as the principal, but the EIN was tied to his Social Security number, which I had found in a document from our tax filing 2 years prior that I had retained a copy of. The LLC had a business account. The business account had received in 11 months $41,000 in transfers from sources I had not yet fully traced. I laid all of this in front of Patricia Nguyen. She was quiet for a long moment. "How did you get the EIN?" she asked. "Our joint tax return from 2 years ago," I said. "He listed consulting income, $62. I thought it was a rounding entry at the time." She almost smiled. Almost. "He's been building this for at least a year. At least. And you haven't confronted him." "No." "Good." She straightened the papers into a neat stack. "Don't. Not yet. I'm going to file a formal discovery motion and a request for financial disclosure. We're going to do this through proper channels, and we're going to be very thorough, and we are not going to give him any reason to prepare a defense he isn't already prepared for." I drove home from that meeting feeling something I hadn't expected. Not triumph, not relief, but a cold and steady clarity. The kind that comes when you stop hoping something isn't true and start dealing with what is. What I didn't know, what I found out later, was that Daniel had driven past Patricia's office building that same morning. He had seen my car. He mentioned it to her that night. I know this because 2 weeks later, a mutual friend named Greta, a woman I had known for 8 years, who'd apparently been closer to Daniel's version of events than I had understood, called me under the pretense of checking in and spent 12 minutes asking careful questions about whether I had found a lawyer and what my plans were. I told Greta I was thinking about it, that it was all very overwhelming, that I wasn't sure what I was going to do. Greta reported back, I was certain of it. Good. Let them think I was overwhelmed. Let them think I was stalling because I didn't know what to do. The formal discovery motion had already been filed. The clock was already running. And Daniel Marsh, who had spent 11 months building a wall around assets he thought he'd hidden, was about to learn that I had been studying the blueprint the whole time. The discovery motion hit Daniel's attorney on a Thursday. I know this because Daniel called me that evening for the first time in 2 weeks. Not to talk, but to breathe differently on the phone, the way people do when they're trying to sound calm and failing. "I heard you got an attorney," he said. "I did," I said. "Patricia Nguyen." A pause. "She's aggressive." "She's thorough," I said. "There's a difference." He hung up 12 minutes later without resolving anything. That was fine. I hadn't expected resolution. I had expected exactly what happened next. 3 days after the discovery motion, I received a letter. Not from Daniel's attorney, but from a second attorney I hadn't encountered before, a man named Stuart Colby, whose firm was listed in the letter header with 4 names and a Midtown Manhattan address. The letter was written in the kind of language that is technically not a threat, but is designed to feel like one. It suggested that the discovery motion was premature and potentially harassing, that my professional background created an unusual conflict of interest with regard to financial evidence I had gathered, and that my continued pursuit of certain financial records could expose me to countersuits. I read the letter twice and then called Patricia. "Colby," she said when I read her the name. "You know him?" "I know of him. He represents high-asset clients in complicated divorces. He's expensive, and he plays rough." She paused. "Do you know why Daniel can afford Stuart Colby?" The question sat in the air between us for a moment. "The LLC," I said. "The LLC," she confirmed. That same week, 2 other things happened. The first, Daniel's mother, Elaine, who'd never particularly liked me but had maintained a cool civility for 11 years, called me on a Tuesday morning and told me in a voice like poured cement that I was making a very serious mistake and that Daniel's family had resources and patience that I would find difficult to outlast. She didn't specify what resources. She didn't have to. The second, I came home from work on Wednesday evening to find that someone had gone through my home office. Nothing was missing. Nothing was visibly disturbed. But I keep my desk a specific way. A professional habit, everything at right angles, papers in a precise order. And things had been moved, slightly, carefully, but moved. I stood in the doorway of that room for a long moment. Then I went to my kitchen, made coffee, sat down, and thought. I did not call Daniel. I did not call Patricia that night. I called Rachel. Someone was in the house, I told her. Rachel was quiet for exactly 4 seconds. "Are you safe?" "Yes, nothing was taken. It was a search." "Claire." "I'm handling it," I said, "but I need you to know, in case." In case of what, I didn't say. She understood. The next morning, I had a locksmith change every lock in the house. I installed a camera system that fed to my phone, a cloud-based system that Daniel's name was not on, paid for with a personal account he didn't have access to, and I moved every physical document of relevance to Rachel's house in Westport in a locked fireproof box that only she and I had keys to. Then I filed a police report about the search, quietly, factually, without accusation, just a record, just a date and a description and my name attached to it. Patricia, when I told her, said, "Good, that's exactly right." The escalation told me something important. They were scared. Stuart Colby didn't come cheap. You didn't bring in Stuart Colby because you were winning. You brought him in because you had found out you weren't as protected as you'd thought. The break-in, if that's what it was, told me they wanted to know what I had, which meant they didn't know, which meant I still had the advantage. After all of it, the letter, Elaine's call, the searched office, I took a weekend. Rachel drove down, we took Biscuit on a long walk through the state park 2 miles from the house, and we sat by a frozen creek and didn't talk about any of it for 2 hours. I needed that. I needed to remember that I was a person and not just a case. I came back steadier. The fear hadn't gone. It had just found its proper place, somewhere behind the clarity where it belonged. There's a particular silence that follows a threat that hasn't been carried out yet. It isn't peaceful. It's the silence of something held in suspension, of forces gathering behind a closed door. For the 2 weeks that followed the break-in, the letter from Colby and Elaine's call, that silence settled over everything like a second winter. Daniel made no further direct contact. His attorney sent 2 more procedural letters, both of which Patricia handled without involving me beyond a brief summary. The formal financial disclosure request was moving through its proper channels. The LLC documentation was in the hands of a forensic accountant Patricia had brought in as an independent expert, a woman named Dr. Susan Park, who had 30 years of experience and who, when I explained what I had found, looked at me over her reading glasses and said, "This is actually quite sloppy work. The transfer pattern is almost textbook." Textbook, that almost made me laugh. But it was during this quiet stretch that Daniel's people made their first attempt at something other than intimidation. It came through Greta. She called on a Thursday evening, the second time in a month, and this time didn't bother with the pretense of checking in. She told me that she'd spoken with Daniel, that she understood things had gotten complicated, and that Daniel had asked her, as a mutual friend, to pass along a message. He was open to a conversation, she said, a private one, just the two of them, no attorneys. He wanted to talk about what could still be salvaged. Salvaged. What exactly, I wondered, did he imagine there was left to salvage? I asked Greta mildly what he had in mind. She said he thought if I agreed to a simplified settlement, the house to him, the investment portfolio split 60-40 in his favor, he would drop any counterclaims and the whole process could be finished within 60 days. 60-40. He'd take the house I had lived in for 9 years. He'd take the majority of a portfolio I had contributed to equally for 11. And in exchange, he would drop counterclaims that, as far as Patricia had been able to determine, had no legal basis whatsoever. I told Greta I'd think about it. She said that was good, that it was the mature thing to consider. She said Daniel was really just trying to move forward. After I hung up, I sat for a moment in my kitchen and thought about what moving forward looked like for Daniel. I thought about the woman he'd been moving toward since at least August, possibly longer. I thought about the LLC and the $41,000 and the carefully timed transfers while I was out of state. I thought about what it meant that he had gone to the effort and expense of Stuart Colby and a break-in and his mother's phone call, and then sent Greta, to offer me a 60-40 split, as though I might be soothed by it. He still thought I didn't understand what I was dealing with. He still thought I was overwhelmed. He had sent Greta because he thought I was the kind of woman who could be managed by a familiar voice and a soft word. I let him think that. The social support I found in those weeks was not dramatic. It didn't arrive all at once. It came in the form of Rachel, who drove down twice and sat with me through evenings I didn't want to be alone. It came in the form of a colleague at the firm named Marcus, who had been through his own divorce 3 years earlier, and who made a habit of leaving a cup of coffee on my desk in the mornings without making it mean anything more than it was. It came in the form of my therapist, Dr. Anita Rowe, with whom I had weekly sessions, and who helped me understand that what I was feeling, the cold, focused clarity I'd been carrying since January, was not numbness. It was a form of grief that had found a purpose, and that was, in its own strange way, healthy. I was not fine, but I was functional, and in the middle of a war, functional is enough. By the end of those 2 weeks, Dr. Park had completed a preliminary report on the LLC. Patricia called me to go over it on a Friday afternoon, and she said something I want to remember exactly. "Claire, you handed us enough to rebuild this case from the ground up. What he put together over a year, you unraveled in 3 weeks. I wrote that down too. They came on a Saturday in March. I had spent the morning at Rachel's, gone over the preliminary report with her over coffee, and driven back to Birchwood Lane around noon. I pulled into the driveway and saw Daniel's silver Audi parked at the curb, and behind it, a second car I recognized, a dark blue sedan belonging to Elaine. I sat in the Honda for a moment. I looked at those two cars and I thought about every phone call, every carefully worded letter, every visit from Greta, every message passed through intermediaries rather than said directly. And now, here they were, in person, on a Saturday, unannounced. That told me something. People who are winning don't show up unannounced. People who are beginning to understand they are losing, they show up unannounced. Then I got out, walked to the front door, and unlocked it. They were standing on the porch. Daniel had his hands in his coat pockets. Elaine stood slightly behind him and to the left, her expression arranged into something that was meant to resemble concern. "We wanted to talk," Daniel said. I stood in the open doorway. I did not invite them in. "About what?" "Can we come inside, Claire? It's cold." "What did you want to talk about, Daniel?" He looked at his mother. Something passed between them quickly. He looked back at me. "I think we've both let this get out of hand. Attorneys and motions, and it doesn't have to be this way. We were together for 11 years. We can be adults about this." "Adults?" I looked at him standing on my porch. The porch of the house I had lived in, that I had painted trim on and hung lights on at Christmas and sat on in the evenings with Biscuit. And I thought about what being adults had looked like when he was filing divorce papers in August while I was in Chicago for work, when he was moving money in careful $4,000 to $6,000 increments, when someone was in my office. "What are you proposing?" I said. Elaine spoke then. Her voice was warm in a way that took effort. "Claire, sweetheart, I've always thought of you as family, and I think if you'll be honest with yourself, you know that this legal process is only going to hurt both of you. Daniel is willing to be generous, but not if you keep—" She paused carefully. "Digging where there's nothing to find." Digging where there's nothing to find. I let that sentence sit between us for a moment. I let it breathe, because that sentence, that particular choice of words, told me something important. It told me that Elaine knew exactly what had been hidden and exactly how much depended on my not finding it. Innocent people don't warn you to stop digging. They ask what you're looking for. "What does generous look like?" I asked. Daniel took a breath, as though this were the opening he'd been waiting for. "The house," he said to him. "But he'd compensate me at assessed value. The portfolio split 50-50. He'd waive any claims against my personal accounts. He'd have it done in 30 days, at assessed value, not market value. The assessed value his attorney had used in the original filing, the one that was 9 months old and 40% below current market. I looked at him. I looked at Elaine. I thought about Dr. Park's report sitting in a locked box at Rachel's house. I thought about the 11 transfers. I thought about the LLC and $41,000 and a registered agent in Delaware. "I'll think about it," I said. "Claire," Elaine started. "I said I'll think about it." I held the door. "It's cold. You should go." Daniel's expression did something complicated then, something that moved through what might have been hope and settled into something harder. "Don't make a mistake here," he said quietly. "You don't know what you're getting into." There it was again. The same phrase he had used before. You don't know what you're getting into. But this time it carried a different weight. Before, it had felt like a warning. Now, standing on my porch in the cold March light with his mother behind him and Stuart Colby's letter already filed in Patricia's office and Dr. Park's report already complete, it felt like something else. It felt like a man repeating an old line because he had run out of new ones. "I know exactly what I'm getting into," I said. "Drive safe." I closed the door. I stood in the hallway for a minute, listening to the cars start, listening to them pull away. Biscuit came and pressed against my leg. The fear came after, not during. It arrived about an hour later when I was sitting on the couch with a cup of tea, and I thought about what Daniel had actually meant by "you don't know what you're getting into." The break-in, Colby, the carefully structured LLC, Elaine's voice, warm and warning at the same time. But the fear, when it came, did something unexpected. It made me angry, and the anger made me absolutely certain. I called Patricia on Monday morning and said, "No settlement, we're going to trial." The hearing was scheduled for a Tuesday in April, in a Hartford courtroom that smelled of old wood and fluorescent light. I arrived 20 minutes early in a navy suit I had bought specifically for the occasion. Not because I believed clothes were armor, but because I wanted to feel like myself, composed, precise, ready. I had not slept well the night before. I want to be honest about that. I had lain in the dark in my bedroom in my house, with the new locks and the camera system and the documents safely at Rachel's, and I had stared at the ceiling and run through every possible version of the next day. Not because I doubted the evidence. I didn't doubt the evidence. I doubted the things that evidence cannot control: a judge's mood, a well-delivered performance, the way a room can sometimes tilt toward someone simply because they are confident and well-dressed and have the practiced ease of a man who has always expected things to go his way. I got up at 5:30. I made coffee. I sat at the terracotta. No, it was still beige then, still the compromise color. I sat at the beige kitchen table, and I read through my notes one last time. Not to memorize them, but simply to feel them under my hands. Then I got dressed and drove to Hartford. Patricia sat beside me at the plaintiff's table. Across the aisle was Daniel in a gray suit I had bought him for a work conference 4 years ago, flanked by Stuart Colby, who was exactly as expensive-looking in person as his letterhead had suggested. Behind Daniel in the gallery sat Elaine in a dark coat, her hands folded, her face performing patience. And behind Elaine in the third row, a woman I recognized. Her name was Melissa. I had met her once at a firm holiday party 3 years ago, where she had been introduced as a colleague of Daniel's. She was sitting 2 rows behind his mother, wearing a gray blouse, looking at her phone. She looked up once, toward Daniel's back. He didn't turn around. I didn't look again. The judge was a woman named the Honorable Patricia Delacroix, no relation to my Patricia, who'd been on the family court bench for 16 years and who ran her courtroom with the efficiency of someone who had heard every version of this story and had a very limited tolerance for embellishment. Colby went first. He was good. I will give him that. He presented Daniel as a reasonable man seeking an equitable dissolution, painted the discovery process as adversarial and financially motivated, and suggested, with careful, plausible deniability, that my professional background had given me disproportionate access and opportunity to shape the narrative of asset disclosure. In other words, he was trying to make my competence look like misconduct. I watched Daniel's face while Colby spoke. He was composed. He had rehearsed this. He was looking at the judge with the expression of a man who believed he had won before the proceedings started, because he had always believed that things, in the end, would go his way. Had they always gone his way? I thought about that. about the promotion he'd been passed over for, about Melissa in the third row, about the LLC that Dr. Park had described as textbook sloppy. Maybe they hadn't always gone his way. Maybe this had been his correction, his attempt to build a life that finally did. Patricia presented our case without theater. She didn't need theater. She had documentation. Dr. Park testified for 41 minutes. She walked the court through each of the 11 transfers, the timeline, the Delaware registration, the business account, and the total. $53,000 moved in various stages from marital assets into a structure designed to obscure them. Not 41, 53. Dr. Park had found more. She was precise. She was unhurried. She explained each step in language clear enough for a layperson and rigorous enough that Colby's objections found no purchase. I watched the judge's pen move across her notepad as Dr. Park spoke, and I thought, she's writing it down. She's following it. She understands. When she finished, Daniel's attorney objected twice, was overruled twice, and asked 3 questions on cross-examination that made things marginally worse for his client. And then Daniel took the stand. I had wondered how he would handle it. He was a confident man, generally, socially at ease, good at rooms, practiced at the kind of easy authority that reads well in professional settings. In the first 10 minutes of his testimony, I could see him finding his footing, settling into the version of himself he'd prepared. Then Patricia asked him about Marsh Capital Consulting, LLC. The pause that followed lasted approximately 3 seconds. In a courtroom, 3 seconds is very long. "It's a consulting entity," he said. "I set it up for potential freelance work." "When did you file the LLC?" Last spring, I think. 11 months before filing for divorce." "Around then, yes." "And the $53,400 transferred into the business account over 14 months. Can you tell the court what consulting work generated those funds?" The second pause was longer. Daniel looked at Colby. Colby gave him nothing. There was nothing to give. "It was exploratory," Daniel said finally. "Early-stage consulting, nothing formalized." "Can you provide invoices?" "I'd have to look." "Contracts?" "It was informal." "Client names?" Another pause. Judge Delacroix looked up from her notes. The room was very quiet. I could hear the ventilation in the ceiling. I could hear someone shift in their seat in the gallery. I did not look back to see whether it was Elaine or Melissa. I kept my eyes on Daniel. That was the moment I knew. Not when we had filed, not when we had Dr. Park's report, not even when I had first found the LLC sitting at my kitchen table on a Sunday evening in February with my legal pad and my pen and the cold clarity of a thing finally known. It was in that pause. Daniel on the witness stand, looking for something to say that did not exist, the story he'd built collapsing under the simplest, most obvious questions. He had built an elaborate structure, and structures built on concealment, I know from 9 years of professional experience, have a particular vulnerability. They cannot answer simple questions. They can survive scrutiny from a distance. They cannot survive invoice, contract, client name, 3 words. That's all it took. He'd counted on me being overwhelmed. He had counted on me signing. He had spent a year building a structure designed to outlast my compliance, and he had never once considered that I might understand it better than he did. What is the cost of underestimating someone? That, I thought, he was about to find out. Judge Delacroix did not rule from the bench that day. She recessed until the following Thursday. In the intervening week, Colby filed 2 supplemental briefs and a motion to exclude Dr. Park's testimony on procedural grounds. Patricia responded to both. The motion was denied. I went to work. I walked biscuit. I had dinner with Rachel on Tuesday evening, and we talked about things that had nothing to do with any of it. Her kids, a renovation she was considering, a book she'd been reading. Normal things. Ordinary things. I had forgotten, in the last 3 months, how sustaining ordinary things could be. I also, on Wednesday evening, went back through my original legal pad, the one I had started on that January Sunday, with the columns and the circled numbers. I read from the first page to the last. 22 pages. The progression of it. The way the picture had assembled itself, piece by piece, out of what had looked at first like nothing more than a missing $27,000 and a privacy screen on a laptop. I sat at that kitchen table, and I read every page, and when I finished, I set the pad down and thought, you did this. Not Patricia, not Dr. Park, not Rachel. They had helped enormously, and I would never minimize that. But the first step, the decision to sit down at a table when you could have fallen apart, to pick up a pen when you could have given up, to write down what you knew and start from there, that had been mine. On Thursday morning, I drove back to Hartford. Judge Delacroix's ruling was 47 pages. Patricia had read it before I arrived and met me in the hallway with an expression I had not seen on her before. Something close to satisfaction, carefully contained. She found the transfers fraudulent, Patricia said quietly. All of them. $53,000 back into the marital estate. The house was appraised at current market value, $412,000. The assessed value Daniel had used in his original filing, the old appraisal, the strategic undervaluation, was rejected entirely. The investment portfolio was divided equally at its actual current value, not the 2-year-old figure from his filing. Daniel's attorney fees, which had included the full cost of Stuart Colby, were assessed against him. And the LLC, Marsh Capital Consulting, LLC with its Delaware registration and its registered agent and its 14 months of carefully timed transfers, was dissolved by court order, its remaining assets returned to the marital estate for distribution. I sat in the courtroom and listened to the clerk read the summary into the record. Across the aisle, Daniel sat very still. He did not have the expression of a man who had simply lost a case. He had the expression of a man who was recalculating in real time, running the numbers, adding up what the ruling meant not just today, but in months ahead, in the job he still had to go back to, in the professional circles where the proceedings had not been invisible. The arithmetic of consequences is slower than the arithmetic of money, but it is just as relentless. I recognized the look. I had seen it before, across conference tables, on the faces of men who had believed their structure was solid right up until the moment it wasn't. Colby was writing something, but slowly, the way you write when there is nothing useful left to write. Elaine was not in the gallery. She had not come. After the ruling was entered, we filed into the hallway. Daniel passed close enough that I could have reached out and touched his arm. He did not look at me. Colby stopped briefly and spoke to Patricia in a low, professional voice about the timeline for compliance. He was not aggressive. He was not anything. He was a man doing the administrative work of a conclusion. I stood by the tall windows at the end of the hallway and looked out at the April street below. People walking, a delivery truck, a woman with a stroller, The whole unremarkable Thursday of everyone else's life going on without reference to any of this. Patricia came to stand beside me. "You did very good work," she said. "So did you," I said. I drove home to Birchwood Lane. I unlocked the front door, the new locks, the ones I had installed in February. And Biscuit came running from the back of the house, nails clicking on the hardwood, and I knelt down on the floor of my own hallway and buried my face in his fur for a long moment. The house was mine. The court had awarded me primary claim. The appraisal was current market, and Daniel had 30 days to vacate and complete the buyout or consent to a sale. He could not afford to buy me out. Not with Colby's fees assessed against him, not with the LLC dissolved, not with $53,000 returned to the marital estate and divided, not with his own attorney now at arm's length. He had come into that marriage with less than I had. He had spent 11 years building something on my foundation and had spent the last year trying to take the foundation when he left. He left with his car. The Audi. That was in the settlement, a concession I had agreed to because I had never wanted the Audi. It was always his. I stood up, walked to the kitchen, and made coffee. It was over. The first spring after the divorce felt different in a way I hadn't expected. Not lighter, exactly. Grief doesn't simply lift, it shifts. It redistributes itself into different shapes. But cleaner, as though the air in the house had changed, had become, finally, entirely mine. I repainted the kitchen. It had been beige for 11 years, a color we had chosen by compromise, which is to say a color neither of us had actually wanted. I painted it a deep, warm terracotta that I had been thinking about since the second year of our marriage, when I had seen it on the wall of a restaurant in New Haven and thought, quietly and privately, that's a kitchen color. I painted it myself over a long weekend in May, with Rachel and her youngest daughter helping, and we played music too loud and got paint on our sleeves, and I thought, this is what it's supposed to feel like. I kept the house. I bought Daniel out. The court sale proceeded on the court-ordered timeline, and between the returned marital assets and my own finances and a refinance at terms that, as a now single income, I qualified for on my own, I kept the house on Birchwood Lane. My house, Biscuit's house. The terracotta kitchen. My work changed too. Dr. Susan Park, who had testified as our expert witness, reached out to me in June. She ran a small forensic accounting practice that handled domestic litigation and corporate fraud cases, and she was, she said, looking for someone with my particular combination of skills and, her word, composure. I gave notice at the firm in July. I started with Park & Associates in September. The work was harder and more interesting and paid, in the first year, nearly what I had made before. I began running. Not as a discipline or a project, just because one morning in June I put on shoes and went out the door and didn't come back for 40 minutes, and it helped in some way I didn't need to fully understand. I ran 3 mornings a week. I ran past the other houses on Birchwood Lane and through the state park where Rachel and I had walked with Biscuit in February, the same creek now running clear and fast in the warmth. And I thought about very little. That was the gift of it. And Daniel. I did not follow his life in any active way, but small things reached me, the way small things do in a town that is not quite large enough for complete invisibility. Greta called once in the summer, and I let it go to voicemail. She didn't leave one. Elaine sent a card in December, a Christmas card. My name written in her precise handwriting on an envelope with no return address, as though I might not know who had sent it. Inside was a generic holiday card with nothing written. I don't know what she intended. I put it in the recycling and didn't think about it again. What I heard through the ordinary channels of mutual acquaintance was this. Daniel had rented an apartment in Stamford. He and Melissa had moved in together, which had lasted, by most accounts, approximately 7 months before it hadn't. He had been passed over for another promotion, a different job by then, a company he had joined when his previous position became uncomfortable in the aftermath of the financial proceedings, a process that had generated more professional scrutiny than he had anticipated. Stuart Colby's fees had been substantial. The dissolution of the LLC had been costly in ways that extended beyond the returned funds. He was not ruined. I want to be clear about that because I am not interested in ruin. He was smaller. His life was smaller than the one he had tried to build, smaller than the one he'd walked away from. He had reached for everything and ended with considerably less than half of what had been there to begin with. Was I glad? I thought about this honestly. I decided I was something more like settled, like a ledger that has been properly balanced, like an account that has been reviewed, corrected, and closed in good order. The life I had after was not the life I had planned. It was better in some ways and more difficult in others, and entirely irreducibly mine. I made decisions in that terracotta kitchen. I had dinners there with Rachel, with Marcus, with colleagues from the new job, with a man named Owen I met at a running group in October who made me laugh in a way I hadn't expected to laugh again so soon. I walked Biscuit every evening down Birchwood Lane and waved at neighbors who had watched all of this from their windows and their driveways, and who now simply waved back. I had been 35 when he handed me that envelope on a January morning. I was 36 when the ruling came down. I was 37 by the time I understood that the woman who had sat at that kitchen table and circled a number on a legal pad, $27,000, 3 circles, had been more capable than she knew. That woman had always been more capable than anyone had given her credit for. She had just needed the occasion to find out. People ask me what I'd do differently. Honestly, nothing. Every hard moment taught me something I needed to know. The real lesson isn't about divorce law or hidden accounts. It's simpler. Never sign away what you've built because someone is counting on your silence. Daniel counted on my fear. He forgot about my knowledge. If you're sitting at your own kitchen table right now, staring at your own envelope, pick up a pen. Write down what you know. Start there. What would you have done in my place? Leave a comment below. And if this story stayed with you, subscribe. There's more to come. Thank you for listening. It means everything.